Good morning, everyone. We are delighted to welcome you to the first webinar in our four-part series in which we're looking at how you can resolve your construction disputes. Today we'll be focusing on litigation. We would describe this series as something of a back to basics, looking at dispute resolution. We will look at the main dispute resolution options of litigation, arbitration, adjudication, and mediation. The law and legal procedures are ever changing and adapting to keep up with the demands of those who use the system. It's always important to keep up to date with the very latest legal and procedural rules, especially given the considerable changes which have been brought about urgently due to the COVID-19 pandemic. I would encourage you to listen again and share with colleagues any of the webinars in this useful series, and the recordings of each will be shared after the event. Just before we begin, to minimise background noise, you are all on mute. If you'd like to ask questions, please do so using the webinar chat function, and we'll try to answer some of these at the end, time depending. So for your speakers today, I am Lee Hurd, an associate specialising in construction and engineering dispute resolution based in our firm's Edinburgh office. I am joined by Ailey Dobson, a solicitor in the team. Both Ailey and I regularly advise on construction contract issues and disputes across a range of projects and clients. Even with the multitude of ADR and alternative dispute resolution processes available, court litigation is still very much a staple of our day-to-day work. Our experiences ranges from actions in Scotland in the Sheriff Court through to the various levels of the Court of Session, and also in England, primarily in the TCC. We act for employers, contractors, subcontractors and consultants across the full range of dispute issues, project types and contracts. This core experience helps to form the basis of our approach and strategic advice for litigation and what we're going to share with you today.
Thanks, Lee. We'll start today with a brief reminder of the background and options for litigation, including the different courts and processes available. It's important to remember that background to litigation, particularly when we look at how litigation processes have been adapted in 2020. We'll then talk about the benefits and the drawbacks of litigation. We'll compare litigation with the other main ADR processes, adjudication, arbitration, and mediation, and we'll then explain the part that litigation can play. As we'll set out, sometimes litigation can make strategic sense in a construction context. We'll then share some of our tips and strategies for participating in litigation. Some of these will be relevant for whichever side of the dispute you're on, whilst others will be specific to whether you're pursuing or defending a claim. Knowing the strategies of the other side can, of course, be helpful in itself. So, for as long as there have been laws governing our society, there have been institutions designed to uphold those laws. In Scotland, the College of Justice was established in 1532, and now includes the familiar Court of Session and High Court. Before then, of course, justice was handed out by sheriffs, kings and lairds. The classical split in the law is between criminal law, which this webinar is not concerned with, and civil law, which encompasses all non-criminal law, such as commercial law, property law, and so on. Construction disputes fall squarely within civil law. We'll first focus on the court system in Scotland. Scotland currently has two tiers of court for civil matters. The lower tier is the Sheriff Court, which has a local geographical remit, usually centred in the old shards of Scotland and now grouped into regions as well. The upper tier is the Court of Session, which is based in Edinburgh, and it has a Scotland-wide jurisdiction. Only disputes worth over £100,000 can be raised in the Court of Session. The Sheriff Court and the Court of Session have separate procedures for how litigation takes place, so there are many similarities. Within each, there are a couple of choices of procedure too, which I want to highlight. Both courts have a commercial procedure, with the Court of Session having 3 judges dedicated to commercial cases. Commercial cases benefit from a higher level of judicial management, meaning that the judges will push the parties on to the next stage rather than letting the parties determine their own litigation route and timescale. This usually requires a lot more upfront work from both parties, but usually results in a shorter litigation and often will facilitate an earlier settlement. That's because the main case investigation and preparation is moved to earlier in the case. meaning that the strengths and weaknesses of each side's position become apparent earlier on. In an ordinary non-commercial procedure, this stage is only reached much later on, which tends to result in more cases settling at the door of court, that is, when the full trial of evidence is poised to begin. It's useful to be aware of the All Scotland Sheriff Personal Injury Court, which is known as ASPIC, which was established in September 2015 following the recommendations of the report of the Scottish Civil Courts Review, which was led by Lord Gill. As expected, this court only deals with personal injury cases. In practice, most personal injury cases are now raised in ASPIC, although some cases are still raised in the Sheriff Court or in the Court of Session. In England, the court structure is different again. For civil matters, the lower tiers are the Family Court and the County Court. After that, there's the High Court, which can hear appeals from other courts as well as first instance cases. Matters can then be appealed further to the Court of Appeal or to the UK Supreme Court. Scottish appeals can also end up in the UK Supreme Court, which was formerly the House of Lords. For construction disputes in England, it's likely your case will end up in the Technology and Construction Court, or the TCC. They're a specialist group of courts forming part of the Business and Property Court of the High Court of Justice. They include both the High Court and the County Court. So after that run-through of the court system in the UK, I'll now pass you over to Lee again to look at the benefits of litigation.
Thanks very much, Ailey. So moving on to the benefits. The major benefit of litigation over other dispute resolution options is really the certainty and finality of a decision, subject to, of course, the court's appeal process. Adjudication decisions, in contrast, are only temporarily binding, and mediation relies on parties actually reaching a settlement or an agreement. If you decide to take a dispute to court, it will be determined and you can be certain of that result. The appeals process isn't a major drawback to that benefit either, as the court appeals process is designed to be a safety net for higher decisions in novel or complex cases, although sometimes appeals are used as a matter of strategy. But it is also important to know that appeals are not allowed unless there are good grounds for doing so. So there is comfort in that. Compared to mediation, you don't need the other party's consent to commence litigation. It's a process which is available whether or not the other party wants it or thinks it's appropriate. It's always available too, and we consider that's a bit more when we think about litigation strategy. In England, the courts have for some time encouraged parties to consider and pursue alternative dispute resolutions before court or face financial sanctions for not doing so. An example of this is mandatory mediation or court-ordered mediation. This approach has not yet been adopted and followed in Scotland, and there's no indication at present that it will be. So for now, a party's option to litigate a real dispute against anyone in Scotland at any time remains, subject, of course, to contractual provisions, for example, an arbitration clause. Unlike adjudication, which, unless provided for in the party's contract, is only automatically available for construction contracts, litigation is available to everyone for any type of dispute. Although in this webinar and this series we're talking about resolving construction disputes, the statutory definition of construction contracts, which underpins the right to adjudicate, does have some limitations and doesn't apply to all contracts in the area of construction. For example, there are a number of excluded operations: oil and gas drilling and extraction, surface and underground mining, assembly and installation of plant or machinery and any associated structures where the primary activity is power generation, water treatment, or in certain chemical, pharmaceutical, oil and gas, and food and drink scenarios. If you have a dispute in any of these types of situations, you'll probably consider a construction dispute, but you may find yourself falling out of the statutory definition of a construction contract within the Construction Act. That means you wouldn't have an automatic right to adjudication, although you may still have a contractual one. In all these circumstances, litigation remains an option unless the contract provides otherwise. The major benefit of litigation is also that a whole dispute can be decided through one litigation. Although that is technically true of all dispute resolution processes, the reality is that some can be quite tricky to resolve. whole large complex construction disputes in one place. Adjudication, for example, is supposed to be a quick, rough and ready process. And although time periods can be extended by the consent of both parties and the adjudicator, a large and complex case can quickly grow to be a daunting challenge for any adjudicator given the timescales. Also, inevitably, it may be difficult for an adjudicator to get to grips with all the complexities, documents, and variety of issues in a large-scale dispute within the tight timescales. That's why in our adjudication webinar, we will mention the recommendation of using adjudication as part of a strategy for discrete disputes or to pick off aspects of a larger dispute. For example, an extension of time or a loss of profit claim in a wider final account dispute. Mediation too can perhaps be practically daunting if there are too many issues on the table, and unless parties are simply focused on numbers or cutting a deal, a complex dispute can often be too cumbersome for mediation and may not end up resolving matters fully or at all. In contrast with these, litigation allows a whole large complex dispute to be taken and worked through in the court process. That inevitably takes time, and the more complex a case is, the more time it will take. But you at least have the knowledge that ultimately you will get a certain decision on the whole dispute. Sometimes having a background in the technical subject of the dispute is cited as an advantage for adjudicators or arbitrators over judges. However, in response to this, for litigation, we would say that today the commercial judges in the Court of Session in Scotland and the TCC in England are very familiar with construction cases and construction law and are generally able to pick up these technical aspects quickly. Finally, litigation can often still be used and seen as a show of strength to the other side. Other alternative dispute resolution processes are sometimes thought of as a softer option, particularly mediation, and this can, depending on your situation, be a drawback to their use. Litigation has the opposite reputation. Given the cost, time and resource commitments of litigation, a party surely wouldn't litigate unless they had some conviction that they had a good case, or that is certainly the appearance you might wish to give if raising litigation. I'll hand back over to Ailey to discuss some of the drawbacks of litigation.
Thanks, Lee. The two major drawbacks of litigation are the costs and the time involved. Past costs are technically recoverable by the successful party. In reality, only a proportion actually are. In Scotland, only around 50 to 60% of a litigant's actual costs will be recovered. There is the opportunity to ask the court for a higher award if your case is particularly complex or novel, for example, but this is not automatic and you have to demonstrate that there's a good reason why your costs are higher than usual. In England, there may be scope to recover more expenses if costs are awarded on an indemnity basis. However, it will still not be full recovery. Costs are generally only awarded at the end of the litigation process as well, once a decision has been reached. That means that anyone pursuing or defending a case generally needs to have a sufficient war chest to cover these costs, at least on a temporary basis. This is a potential access to justice issue, and it's been considered a lot in recent years and has resulted in a fairly buoyant market for third-party funding of litigation. This removes the war chest issue, as the third party will essentially fund the litigation for you. In return, though, they will be entitled to a percentage of any payment eventually awarded or settlement achieved, and there will usually be fairly onerous reporting obligations. It's something we're seeing far more of, though, certainly for larger cases, and it's something always to keep in mind. The length of time litigation takes can add to the cost. Litigation activity is arguably at the lower level of intensity to what is required in adjudication, for example. This can be a benefit, as litigation will not divert senior management time in the short term to the same extent or intensity of adjudication. However, because litigation takes place over a longer period, higher costs ultimately are borne. The time that litigation takes can be a major drawback. Any significant dispute will likely take more than a year to get through to a final decision, and sometimes significantly longer. Even the time taken to launch a litigation, notifying the defender and allowing them the time to say whether they're going to defend the case or not and to prepare some initial defences is longer than the whole of most adjudications. There are some ways of mitigating this, for example, by using the commercial court procedure in Scotland or the TCC in England and benefiting from judicial case management, but even in those circumstances, the court process is still relatively slow. Parties also need to be aware that in litigation, you're handing over control to a third party. That has benefits. An objective, dispassionate view is taken to the dispute and the party's position, but it also can be a drawback, as the parties may in places feel adrift from the process. Also, there's no room for a novel solution, as there may be in mediation. The court will simply decide on the merits of the case. Litigation can be a very public process too. Hearings are usually heard in public, and cases are reported in the papers and in legal journals. This can have a strategic benefit in some cases, as it can put pressure on the opposing party. However, be aware that you can't control headlines. The press may take a different angle in the matter that is less favourable than you expected. If litigation seems to be the best way forward, but publicity aspects are a concern, then arbitration may offer the best alternative for a final binding process if the parties agree to it. Another point to bear in mind is that relationships between parties rarely survive litigation. The process is adversarial. If you plan to continue working with the party on the other side of your dispute, a different process may be more suitable. Mediation offers the best way of retaining a relationship, but even adjudication, dealing as it does with issues quickly, may not damage a relationship beyond repair.
Thanks, Ailey. So when should litigation be used? We'll look at this before we move on to looking at tips and strategies. So in our webinar on adjudication, we'll explain that one of the most effective strategies for resolving construction disputes generally is to first use adjudication to deal with some discrete issues or to narrow the issue in dispute between parties, and then perhaps seek a mediation or a different process to conclude the dispute. So where does litigation fit in? Litigation is often the background to these other dispute resolution processes and can be used to keep pressure on the parties while these other avenues are explored. In a complex construction dispute, it's likely that both parties realise that the dispute is real and needs to be resolved, but may be slow in acting. The threat or initiation of litigation can help get things moving. Litigation is often the last option parties consider, as it's often known to be a long, drawn-out and costly process. In that sense, it can sometimes become something of a strategy of last resort, pursued when all other avenues have been explored. However, there are times when litigation is a good starting option. For example, you may feel that compromising is just not an option for your dispute if you think the other side is wholly to blame for a particular event or unwilling to move. In some disputes, there may be room for compromise, for example, in a final account dispute with various different issues, and you may be looking for a final decision to be made one way or the other. Adjudication would be an alternative here, but a complex legal and technical issue may be unwieldy for an adjudicator, and you may fear being caught out if the arguments and technical aspects are not given a proper aiding, again due to the tight timescales. Also, litigation is often an effective means of flushing out strengths and weaknesses of the other side's case. This might involve pursuing litigation part of the way and then exploring an out-of-court resolution, possibly a mediation. This is often an effective strategy, and litigations generally rarely conclude or make it to proof in Scotland or trial in England. One thing always to consider when deciding on your strategy is the question of prescription in Scotland and limitation in England, or time bar, because your right to make a claim will have time limits. There may be circumstances where you need to commence a litigation to interrupt prescription or limitation, and then pause while other approaches are worked through to decide whether those will resolve the dispute or whether the litigation will need to go ahead. Adjudication is not effective in stopping the clock, so to speak, for prescription or limitation, and whilst arbitration can be, we generally see litigation being used to stop the clock for prescription or limitation in practice. Standstill agreements are also possible in England, which essentially would prevent the need for a litigation to be raised as it's an agreement to postpone or enter into a period so there won't be limitation in England. At the moment in Scotland, there's no ability to enter into such a standstill agreement. Once the Prescription Scotland Act 2018 comes into force, there will be an ability for such agreements to postpone the 5-year prescription period, but only by 1 year and only to be used once. Just to be clear, this is not yet in force, but we expect once it is, there will probably be an uptake in such agreements, which may then result in a reduced number of protective proceedings being raised through the Scottish courts. So moving on to important strategic and practical approaches that one might take to litigation. So the first is really to construct your litigation team, choosing your solicitor and your advocate, or solicitor advocate, depending on your dispute. You may also need an expert witness for a technical aspect, or a quantum specialist, or in fact, multiple experts depending on the type of dispute. These people need to be right for their own task, but also need to work well together, particularly if a case is going to go on for a number of years. Also, experts should not only just be an expert in their field for experience, but also competent at writing reports and appearing in court and under cross-examination. If you're the side wanting to launch a case, you have the advantage of choosing when to launch it. Using this advantage and carefully choosing when to raise proceedings against the context of other ongoing discussions is important. Be careful that the time is right, as commencing a case where discussions are ongoing may result in the discussions breaking down. Equally, if discussions about resolution are progressing slowly, a court action may be threatened or even raised to prompt action before all the true expenses of litigation start to really bite. You must wait until that you're at least certain that you have a stateable case before proceeding with litigation. You cannot raise unfounded or speculative actions without some basis for the claim being made. You can be led by your solicitor on this. In saying that, you also don't have to have worked out your entire position on every single part of your case before commencing. It's normal for investigations, expert reporting, further reports, etc., to all continue during the early stages of litigation. If you're concerned that court action may be raised against you, whilst it never hurts to prepare at that stage, the need to do so is perhaps less urgent or rushed than, say, an adjudication, as the court timescales generally provide a reasonable and sufficient time for a defender in Scotland or defendant in England to conduct their investigations, instruct experts, and so on. For either party, you should consider whether you have all of the documentation needed to pursue or defend your case. The court process has mechanisms for the recovery of documents necessary for the case, which can be valuable if you don't have good records yourself. This isn't an option in adjudication where you're reliant on the records and documents you actually have or those offered by the other side, because the other side doesn't have to display anything unfavourable that you don't know about. As a defender, a tip is to put forward all possible lines of defence, including potential counterclaims and set-offs. Defences can be properly constructed with a number of alternative arguments, and this is normal and pragmatic. The court and judge will not consider this to prejudice any primary position adopted, so long as it's made clear how your positions interact. If at any stage either party realises their position is weaker than initially thought, it's worth carefully considering whether or not you want to see through the whole litigation process, or whether you're at a stage it's better to negotiate a resolution to curtail the ongoing time and costs of the process. The courts are comfortable with such an approach, and indeed the court process allows for judicial settlement offers to be made, tenders in Scotland, which are made by the defender, and pursuer's offers as well, which are made by the pursuer. These can be effective as they force the other side to seriously consider their prospects and settlements. If you do not accept a tender or a pursuer's offer, and then do not beat that offer when the case is decided, there's an adverse finding in expenses for you from the date of that offer or tender. In the case of a pursuer's offer, an additional uplift is made to those expenses. Given the potential cost implications, tenders and pursuer's offers are useful tools in litigation. Finally, and as mentioned briefly earlier, For those considering pursuing significant litigation claims, litigation funders now have a range of sophisticated litigation funding models, which may assist in funding your litigation. These essentially turn a good litigation claim into a monetised, off-balance sheet asset. The funder will want a return on its investment, obviously, but in doing so, it takes some of the risk and will remove the cash flow issues that might have ordinarily stopped a claim being raised. Shepherd and Wedderburn are at the forefront of the litigation funding market, and we are currently working with a number of leading funders in this area.
We'll look now briefly at how the courts have adapted in 2020 to the COVID-19 pandemic. As of today, the majority of court and tribunal buildings are physically open in both Scotland and England, but access is heavily restricted and most procedure is still being carried out virtually. There are benefits to this virtual procedure. Time obviously is saved travelling to court and waiting for your case to be heard, and you're able to prepare your physical environment in advance. It's important to remember that virtual hearings, whether by call or video link, remain formal court processes. Lawyers and witnesses must dress appropriately for a video hearing and ensure they're in a quiet and secure space. Just like in physical court, the proceedings must not be recorded by any party. At the start of the pandemic, more than one journalist inadvertently fell afoul of this rule, and images of a virtual hearing in a high-profile case in the English High Court were shared on Twitter. The judge was quick to stamp down on that behaviour and to remind attendees that they were at risk of being in contempt of court. Witnesses, too, must remember that they're giving evidence in a formal court hearing, even if they're taking part outside of a physical courtroom. In a recent case, during a short break midway through giving their evidence, a witness telephoned a former colleague to ask for feedback and instructions. Discussing evidence in that way wouldn't be acceptable in a physical court, and it's not acceptable in a virtual hearing either. The witness's conduct came to light as he left his microphone on during the call. IT challenges can be a feature of virtual hearings. To deal with these challenges, the use of virtual hearing service providers is becoming more and more common. These providers can provide a platform which hosts the hearing, offer a document presentation service, and provide full transcripts of proceedings. This can be beneficial in that it allows parties to concentrate on the legal issues at hand, although the sometimes high cost of using these services may be prohibitive in lower value hearings. The administrative side of conducting litigation in a virtual atmosphere has been helped considerably by legislation. In Scotland, for example, the Coronavirus Scotland Act 2020 has allowed the use of electronic signatures and electronic transmission of documents, whereas previously it was often necessary to sign court documents by hand and then to deliver paper copies. Many of these provisions do make litigation easier, and it'll be interesting to see how the court system adapts again to life after COVID-19. We certainly hope that a pragmatic approach will be taken and that, for example, electronic signing of court documents will become the norm. While court hearings in person are likely to remain preferable for substantive hearings, many procedural hearings can take place just as effectively by virtual means, and that often saves considerable cost. We expect these sort of proceedings may in the future be more prominent. We've come to the end of the presentation now, which we hope has been useful and interesting, and we still have a few minutes to answer any questions. If you haven't already done so, please type your questions into the chat box now. While you're doing that, I'll take the opportunity to remind you that all 4 webinars in this series will be recorded and made available on YouTube and on LinkedIn to enable you to listen again or share with colleagues. You'll be sent a link to this recording after the webinar. So we have a question here about COVID-19. Is there a court backlog caused by COVID-19? And what are the implications of that? So there's been a lot in the news about the backlog in the justice system that's been caused by lockdown, and that's usually in relation to criminal cases and the difficulty of running socially distanced jury trials. For construction disputes and civil disputes, that's a little bit different as there isn't usually a jury. We understand there is a bit of a backlog with civil business, and I suppose that's inevitable given the time around the start of lockdown while the courts adapted to new ways of working. I think that what we are seeing is the courts taking a proactive approach and really being willing to use available resources, using technology to keep litigation moving. And where there's a particular urgency, if your case is close to time barring and you need to raise proceedings urgently, for example, procedures are in place to prioritise those sorts of cases. Another thing to remember is that most construction cases can be raised in the commercial court in Scotland or in the TCC in England, and those courts taking the proactive approach that they do can help to speed along the litigation process, which might be helpful, particularly in the current environment.
Yes, I think that's right, Aileen. I think the only thing we can also say to that is we're seeing generally turnaround times by the court are probably quicker in a sort of post-COVID or during COVID environment, where we're seeing summons in the court session being signated the same day or next day, etc., not having delays. So although there might still be longer hearings which are backlogged a little bit, the sort of day-to-day approach has been fairly efficient since the courts opened back up again in sort of the May, June time. I see we have a few more questions, but I am aware of time today. So given the time, we will come back to those of you who have asked questions by email shortly, and thank you for that. So it just leaves to me to say, well, that's our time up for today. I do hope you've enjoyed the webinar and found it informative and useful, and we look forward to welcoming you to future webinars in the series. Thanks again, everyone.